Well, good morning, everybody. Thank you so much for joining us this morning in our Continuing in the Trenches series. I'm joined today by my partner, who you've been hearing a lot from as we present these, Craig Nazzaro. We're continuing today with a series of updates regarding the last few weeks relating to the Paycheck Protection Program, loan programs. Got a really interesting topic set for today that we'll kind of go through, and we're going to look at it from two aspects. One is a series of updates for individuals who are borrowers under the Paycheck Protection Program, and then we're going to talk about a number of developments that are significantly impacting lenders under the Paycheck Protection Program. And so we're going to split it up in essence in half. Craig's going to be talking about a lot of the updates for lenders and the recent changes that we've seen over the last 2 weeks. And then we'll be talking a little bit about information for borrowers, as many of you who are in financial institutions may be getting calls from borrowers with questions about the program. Many of you candidly, maybe like myself, where you have still remaining questions about how the program is going to operate, exactly how the forgiveness is going to work, and what are the restrictions on expenditures, because there's a number of unanswered questions that are still awaiting clarification as we talk about moving into phase 2 of the Paycheck Protection Program, which is the repayment period and the forgiveness calculations. One thing just to kind of put everything in perspective for us today is here is the current data from the PPP program. These are the latest numbers current as of May 1st, the last release by the SBA. We expect a new release tomorrow to come through. But if you look at PPP round one, in terms of kind of overall observations, you saw that there were a lot larger loans in PPP round one, whether that's a result of the order in which banks contacted potential borrowers, or simply the people who were immediately applying for PPP were those that had significant financial resources, large payrolls, who were able to process those applications much more quickly. What I want to really draw your attention to, because it's going to come up here in a few minutes, is if we look at Paycheck Protection Program round one, the average loan size was $206,000, which means that if you're kind of looking at your own PPP loan and trying to decide where you fall within that range, if you're above $206,000, you're above the average loan size. And if you really take it down by number of loans, you see just how many of the loans were for less than $350,000 and less than $150,000. So by total number, 74% of the loans, almost 3/4, were for less than $150,000. Compare that to the PPP round two, when you see that those numbers continue to fall, which is good news. I mean, it looks like we're impacting the small businesses that are designed to be helped by the PPP program. Already there are more loans that have been processed in PPP round two, but only about half of the approved dollars, which inherently means that we're lowering the size of the loan. 79,000 current average loan size for PPP round two, and even more striking, 96% of those loans are for a total loan amount of $350,000 or less. Only 4% for larger amounts. One thing I would remind you, I forgot to mention this earlier, if you do have questions that come up as we go through today's presentation, feel free inside the GoToWebinar portal. There is a tab called Questions. You can send those questions anonymously to any of the presenters today, and we'll try to address them either as we're moving through or alternatively at the end of the presentation. Let's talk a little bit about what's been happening in the last few days and how this has impacted borrowers. Just a few headlines that we've been seeing, and this has really sparked a lot of the controversy, which is you had some media outlets that began investigating the recipients of PPP loans, particularly those that were publicly traded, because they were having to report that they were accessing this money. One thing you should know, eventually there is a delay that occurs, but all PPP loans, including their recipients, will be made public. This is a governmental loan, similar to an SBA loan. So at some point in the future, the borrower's name, the borrower's amount can be released by the federal government. These, however, were public companies, so people were able to access information regarding, based on their public filings. But you saw this huge backlash. You had large companies, and everyone was talking about, Harvard University getting a PPP loan, Ruth Chris, Shake Shack, the Lakers, the basketball team, all getting these PPP funds. And what you saw was this public backlash. Now, a little bit of that is a misunderstanding of PPP. There are actually multiple programs in PPP, and a lot of the restrictions that applied to small businesses did not apply to folks in the hospitality sector. And so you were able to see a lot larger businesses potentially come through under the hospitality provisions, as opposed to your typical small business. But that being said, you still have these big names, and with that then came this backlash. You saw people going on interviews on the news stations and saying this isn't fair. I've got true small businesses, the person who runs the grocery store, the convenience store on the corner, and he or she's not able to go out and get a PPP loan because these large companies swallowed up the limited pot. Obviously then that changes when Congress reauthorizes an additional flow of money into the PPP program. And with that, then you see a change to the rules. And I should say a change to the interpretation of the rules. If you think back to when you made your loan application for the PPP, there was a series of certifications contained in that application. That's what we've got here on the screen. And most importantly is there was a certification that the loan request was necessary to support the ongoing operations of the applicant. So we'll talk about this in a minute, but there's allegations that a number of people had shuttered their business, particularly those that were subject to shelter-in-place orders. They weren't operating. There was no ongoing operations. Well, one of the certifications is it's necessary to support ongoing operations. Similarly, and this is the one that's getting all the headlines, is that the funds will be used to retain workers, maintain payroll, make mortgage interest payments, lease payments, and utility payments. In essence, you have to use them for these limited purposes. The final one that we'll talk about is the one that is really the biggest concern, which is this question of necessity. We know that when this program was started, the SBA said, we're going to relax what we would normally require for an SBA 7A loan, your typical SBA loan. SBA is supposed to be a lender of last resort, meaning you've gone to other lenders, you've tried to get the money, that money wasn't made available to you, you couldn't access other funds at a reasonable amount, and so you turn to the SBA. This is somewhat different. They said we're not going to require that, but they also said there is a necessity component of this, meaning you must have made a certification in good faith, taking into account your current business activity and your ability to access other sources of liquidity in a manner that's not significantly detrimental to the business. And we'll dissect that a little bit. That's the extent so far of what the SBA has given us in terms of guidance on that necessity certification. It's in one of the FAQs that was recently updated at the end of April. As of 2 days ago, there has been indication that they're going to send further updates. Everyone's hoping there'll be some sort of clear test for this necessity standard, but the deadline to decide whether you're going to return the money was May 7th today. It's now been extended to May 14th. And as part of that extension, when they said we'll give you until May 14th to decide whether you need to return that money, they also said we're going to issue additional guidance. As of the start of this webinar, there was no additional guidance yet posted, but we expect it either today or tomorrow, just so that folks have time to consider it. If it is something where there is no necessity, then at that point, they are giving everyone a grace period. No questions asked period. The money can be returned to the financial institution, and there'll be no investigation as to whether or not those certifications were accurate at the time that they were made. Let's really kind of break that down and break down the elements of that FAQ, which is, was the borrower able to access other sources of liquidity? This is what we talk about with those headline risks. If you are a publicly traded company and you could go to the markets to get additional capital, you could have gone to the bond markets. Potentially, if you're a part of a private equity portfolio and had ready sources of capital, there you're potentially crossing over that ability to access other sources of liquidity. Similarly, if your business had huge stockpiles of funds, we were talking to a borrower a few days ago, and you know, truly sad story. It was a nonprofit that had been shut down because of the uh, current restrictions. And at that time, they said, do we need to refund the money? Because they had almost $8 million in this nonprofit and operating account, but it was all restricted. And so, one of the concerns that had been raised at that point was, do they need to refund it? They have this $4 million operating account. And, that nonprofit has decided they will because of the concerns associated with that. The other thing to really remember, and we'll break this out a little bit further, is it's got to be able to be used to support ongoing operations, and the access of that funding must not be significantly detrimental to the business. And so, we've had some people call up and say, was the SBA expecting me to, put up all my personal funds? Well, no, the SBA specifically waived the requirement of a personal guarantee. Was the SBA requiring me to start, mortgaging out properties and things of that sort? Well, no, there was no collateral required for these. And so I think, as we think about the current FAQs, and we'll, like I say, to be determined what will come of this, we need to think about it in context, which is, it appears the SBA does not want you to go and do things that will long-term harm your business. But at the same time, if you weren't impacted by COVID-19, probably not necessary. If you had ready sources of funding, likely not necessary. If you had access to other sources of credit, likely not necessary. But again, we get back to that reasonableness standard that we're talking about. One of the things we've been advising folks is to really kind of understand the nature and purposes of the PPP. The PPP, if you read the guidance, had a stated purpose to provide direct, immediate incentives for small businesses to keep workers on payroll. And so in that context, the more that those small businesses are using those funds to keep workers employed, the more likely it was that those funds were necessary. Were you keeping people off of the unemployment rolls during that 8-week forgiveness period? Again, evidence that this was necessary. And then, if not, then the purpose of the PPP was to provide forgivable loans to employers that keep payrolls intact. And so you'll notice that in all of those statements that have come out, there is this aspect of immediacy. There's got to be direct use, immediate incentives, keeping things operational. One of the questions we've had a lot that has been raised by borrowers is someone like a movie theater. Maybe it's a restaurant that's been fully shuttered, no operations. That's when you need to talk to your attorneys pretty carefully about whether or not you were at that time eligible, and whether or not that certification about immediate uses to maintain payroll is something that may come back on you. So, there's a lot of kind of edge cases, a lot of gray area. We'll still see if there's actually going to be formal guidance issued that gives us a calculation. But if not, this is kind of the state of play as it stands right now. What has led to a lot of this concern is Secretary Mnuchin was giving an interview to the Wall Street Journal. And during that interview, he let slip that they were planning to issue guidance that any recipient of $2 million or more is going to be subjected to an SBA audit. Similarly, the SBA has said it can review any loan, and that review will follow the submission of your forgiveness application, when you submit your expenses for that 8-week period. And so reading between the lines there, they don't like the big ones. We're going to audit all the 2 millions and up. And we saw that's really not a lot of borrowers. That's a fairly small number in terms of number of loans. And that they're going to do it only after you've submitted your forgiveness application. And from that, we can gather that likely they're going to use the data regarding the use of that money during the 8-week forgiveness period to guide how they think about audits. Again, we expect that updated guidance is forthcoming. The lenders are all waiting on information on how we're going to process forgiveness applications. Borrowers are all waiting on updated guidance on those borrower certifications and how we should read those. What we're advising all our clients, and this is not unique to our firm, everyone in the world is telling folks this at the moment, is keep documentation. Make sure you've got good, clean records of your company's, your business's financial condition at the time when you applied. Make sure that if you were looking at forward forecasts, you're documenting that. If your industry was being affected and others were telling you that their business was slowing, document that. If you were looking at cash flow projections and you were saying, well, it's time to start making hard cuts, document that. If you were having to lay off people and already reduce salaries, make sure you're documenting that. I mean, all of this is good documentation that's really important later for when it's challenged. Similarly, we've had people call and say, I haven't been impacted immediately, but people were calling and canceling contracts in May and June. Again, document that. Most importantly, remember the purpose of the program. It was payroll. Keep people employed, keep people off of unemployment as quickly as you possibly can. And so if you are to the point where you're making those hard choices, you are cutting salaries, cutting hours, cutting wages, that to me is kind of the silver bullet documentation. You had burned through what you could, and now it was time to start cutting the people. Not only is this important from the standpoint of purposes of the Paycheck Protection Program, but also this plays into how you're going to tell your story should it come up. It had come to the point where you were going to start letting people go. Maybe you had already let them go. A lot of these loans only started in the first weeks of April, and a lot of people made those hard choices in March. If that's the case, make sure you're documenting that extremely well. Keep all of these records. This is our little checklist that we've been running through. One of the questions that someone has posed, and we'll try to address it a moment ago, is if a borrower is going to lay off staff without the funds, that was okay at first. And so that's right. I mean, we're talking about documenting that. Should a borrower have terminated the employees if they had other funds but no work? That's one of the biggest questions that these folks are hearing. That gets back to it, which is if you were planning in advance, and that's why documentation is so key, is it doesn't mean that the ship was sinking at that moment, but if you were looking out and you could see the rocks that you were coming up on, that's what you want to document. Make sure that as you were looking at those projections, you're saying my people are canceling contracts, my accounts payable are getting older and older and older, my accounts receivable are getting older and older and older. I can't continue operating the way it is, and I'm getting ready to start making cuts. Document that. Show that the next step was going to be people, wages, salaries, and hours. If we're talking about who are the potential targets of an audit, this is kind of like asking your accountant, is the IRS going to audit me? No one knows the answer to this. But if we're reading some of the guidance, what has been the hot button issues, here are the folks that we think need to be worried that they're going to be particularly a subject of focus. Obviously, anybody getting more than $2 million in funding is going to be audited. If you're in the upper half of the funding range, more than $206,000, you're in that kind of top 15% or so of borrowers, you may be subject to audit. If you weren't making cuts in a preservation mode, maybe a question of audit. That's why you want to document why you are planning for preservation. If business was operating as normal at the day you made that application, make sure you can go back and substantiate, yes, that was the case, but at the same time, here's why I was preparing for the cuts to come. If you don't use a lot of the money during the 8-week period, we know they're only going to do the audits after you submit your forgiveness application. That's an easy data point for the SBA to look at. If you didn't use a lot of the money for employees and instead you were using most of the money for these, quote, other eligible expenses, that's going to be a problem. We have the 75% rule, which means at least 75% of your money must be used for payroll costs. You cannot use more than 25% for the other eligible expenses, meaning utilities, rent, mortgage interest. That being said, if because of large payroll cuts, you're submitting, say, a 10% forgiveness application, it now looks a lot more like you're trying to obtain an inexpensive loan, as opposed to the purpose of the program. What all of the guidance has said is the purpose was to keep people employed, keep people off the unemployment rolls. Yeah, if your business is actually one that may have benefited from the pandemic, we've seen that a few times as well, where someone was worried that things were going to go poorly, but then the grocery stores have actually been operating revenue positive. There are other kind of edge businesses, folks that sold cleaning supplies and whatnot, who may have been benefited, may want to take a close look about that necessity. One of the things I've heard, and I want to add this because I think it's important. If you are spending on optional purchases, suddenly management is getting, new corporate cars, or you are continuing to make large donations, you are continuing country club memberships, you are making large capital expenditures, big investments in new equipment, buying other businesses. Anything like that is going to play against that argument that these funds were necessary because of the impact of COVID-19. And then because there was a whole question at the beginning of the program whether these groups would be eligible, we think there is a significant concern that there may be scrutiny of private equity portfolios or folks that are venture capital backed, just because arguably there may be other sources of capital that could come into play. As you're a borrower and you think about forgiveness, remember these restrictions. There's only 3 areas that you can spend in addition to payroll costs. Most importantly, everyone who got a PPP loan should have 8 weeks from the day that those funds came into their account circled, highlighted, underlined, and written in red. That's the forgiveness period. The day the money hits your account plus 56 days. That's it. Any money that is spent outside of that is not going to count for PPP forgiveness. So, big highlighted date, make sure you're aware of it. And then understand there are restrictions on how that money can be spent. 75% has to be paid on payroll costs. We'll talk about what's included in that. You can spend up to 25% on the next 3 categories. Mortgage interest, as long as the mortgage predated February 15th, 2020, meaning during the COVID crisis, you couldn't start a new mortgage. Rents on leases that started before the crisis, and then utility payments for services that started before the crisis. All of those are fair game for eligible expenses subject to forgiveness. Understand that you have these restrictions. The 25% bucket, think of it as 2 buckets, your 25% bucket, your 75% bucket. Only 25% can be used for non-payroll expenses. Also, big warning flag, make sure that those payroll expenses are incurred and paid during the 8-week period. Meaning, if people are working during that 8-week period and you don't run an off-cycle payroll, you may be leaving money on the table outside the forgiveness period. You must have paid the funds during the 8-week period. And so if you think about that, if people are being paid on a 2-week cycle, 1-month cycle, what have you, your payrolls may not exactly line up with this 8-week period. It cannot be extended. The 8-week period is absolute. It starts the day you receive the money. Very important. Now, if you do need to do that, run an off-cycle payroll, pay those people for the time that they've worked and make sure that you get the maximum forgiveness. We've had some people say, well, can I prepay expenses? Can I advance money, pay a big bonus to my employees so that it occurs during that 8-week period? Generally, no, you can't advance money. You may be able to pay certain ordinarily occurring bonuses, but you don't want to do, extraordinary abnormal payments, because the test is 2-part. Obligation incurred, meaning the employee worked and the employee was paid during that 8-week period. There are some provisions, like if you do 401k matching or long-term incentive plans or what have you, the proportional amount that occurred during that 8-week period can be counted as long as it's paid and actually paid out of the funds. Remember, you can't set aside the money. You actually must pay it over to a third party for it to count. So we have a little example here, where if you're looking in the future, want to come back for reference, all these slides will be available on the website along with all of our In the Trenches programs. But just understand, and what this kind of plays out is, because of the 75% cap, if you're not using the full 75% on expenses, there's a potential problem there. because you're going to leave forgiveness money on the table. One loophole that we're hoping is going to be closed is, if you think about it, we're comparing the amount of salary during an 8-week period to a 12-week period. The amount you were funded was 2.5 months worth of salary or payroll. Inherently, there's going to be some discrepancy there, and we'll talk about that. We're still waiting to see if some of that's going to be fixed in updated guidance. Quick reference for you here, if you have it, eligible payroll costs, obviously you've got your normal wages and salary. Make sure that if you're paying paid sick leave, you're not double counting it. There was a credit that was issued for paid sick leave for folks impacted by COVID. As with all things IRS, you cannot double dip between the two. Then if you're looking at group health benefits, that's absolutely fine. Profit sharing 401k. State or local taxes can be included in your calculation of expenses. Note that is state and local, not IRS funds that are paid to the federal government. Also remember, and this is very important, you cannot count amounts that you pay to an employee beyond $15,384. They're not protecting salaries above $100,000. They will protect up to that. So if you had an employee that was paid $200,000 annually, and you paid he or she that amount in the 8-week period, they're capped at $15,384 with the first $100,000. Let's talk a little bit about the obstacles to forgiveness. We had a question come in that I think this may answer, which is, remember, any amounts you didn't pay during the 8-week period is not subject to forgiveness. And then there are 2 tests for further reductions. One is if your full-time employees have dropped, that's a problem. There's going to be a reduction. If you reduced pay by more than 25% for employees making less than $100,000, also subject to a reduction. Let's run through some of those scenarios just so you can see how they play out. When you calculate the number of full-time employees, you look at the number of full-time employees you averaged per month during the 8-week forgiveness period. And then you compare that to one of 2 time periods. February 15th to June 30th, 2019, that's particularly helpful for seasonal employees. We've had some people come to us and say, I have a seasonal business. We had somebody call and ask about that they run a bed and breakfast, and most of the people visit in the spring and summer, and so it may be advantageous to pick that seasonal calculation where you go to the 2019 numbers for the same quarter, or the number of full-time employees you had between January 1st and February 29th of 2020. That way, if your business had to downsize in early 2020 before the pandemic really hit, they'll allow you to use that as your comparison point. Remember, a full-time employee works 30 hours per week, and if someone was working less than 30 hours per week, they count as 0.8 or 0.6 or 0.5 of a full-time employee. Here's the kicker. When you compare those 2 numbers, if you went through the crisis with 10 employees and you had 20 employees during those prior periods, then you're going to be subject to a 50% reduction in your forgiveness amount. Whatever the amount you submit for forgiveness, it's reduced by that percentage. So a huge penalty if you let employees go during that period. Similarly, if you had an employee that made less than $100,000 annually and you reduced them by more than 25% from the last full quarter, so for everybody almost, that's January 1st to March 30th, because that would have been the last full quarter before you got your PPP money. You compare their wages during the 8-week period to the last full quarter, and then that is a dollar-for-dollar reduction to the extent that reduced more than 25%. Put a little calculation there. Again, this is either a flaw in the calculations or it's intentional. If you think about it, the amount you paid any employee in a full quarter, 12 weeks, is going to be more than you paid that employee during 8 weeks. And so because of that inherent flaw, there's always going to be a reduction in wages penalty. Still waiting to see if that's going to be corrected. The AICPA, one of the associations for CPAs, has been hounding the SBA about this flaw. But if you take it literally as it stands now, you compare what you paid an employee during 8 weeks compared to what you paid the employee during 12 weeks. And if it's more than 25%, you've got to count the amount beyond the 25%, dollar for dollar, to reduce the amounts that were that were going to be forgiven. Had a question come in, pretty interesting one. If you had a corporation with a single shareholder and that shareholder has significant personal liquidity, will that negate the necessity of the PPP loan? Really interesting question there. You know, if you have a shareholder with liquidity, I think one of the things you'd want to carefully consider is what has been the history of that shareholder using their personal finances to support the business. If it's something where there was never in the past individual shareholders or principals of the business injecting their own personal money into the business, I think you would want to point to the reasonableness of whether they should have at that point put that money into the business. And so you're going to be focusing on that reasonableness of the other sources of liquidity. If it's something where the business has traditionally operated at a loss and that person kept putting their personal capital in and suddenly stopped, you may have an issue that you need to talk to an attorney about. The interesting thing is we've got this safe harbor that's been created, and so it gives you a little bit of protection, which is if you return your number of full-time employees to the level you had between February 15th and April 26, 2020, and you restore their salaries, there's no reduction. So you might be thinking, well, gosh, there's automatically going to be one of those FTE salary reductions because the 8 versus 12 week. And if I let people go, it's a really bad penalty, the percentage reduction. And so between those two things, a lot of people are saying, okay, this is kind of the big incentive, which is if you return those numbers by June 30th, 2020, that's what's important. Neither of those reductions apply if you maintained your workforce. Also, a huge number of people have been asking about what happens if I went out to employees, and because of the benefits right now that are available for unemployment, and I said, hey, I would love for you to come back to work for me, offer you the same package you had previously, and the employee says, no thanks, I'm happy to draw unemployment. Then in that case, you need to document it. You've got to show you made a written offer to return them to the same salary, wages, and hours as previous. And you've got to document that the employee rejected the offer. The other interesting thing is in the SBA guidance, it mentions, and talk to your attorneys or your accountants about this, that you and the employee may then may have an obligation to notify your state unemployment commission that employee is refusing to come back to work. Here is a calculator we're using with a lot of our clients. We're doing some final revisions to it and we'll be making it available on the website. But if you think about how this calculation works, we have here a hypothetical where we had a business that was doing about $50,000 a month in eligible payroll costs, plus the other expenses that were allowable. Multiply that by the PPP multiplier, you end up with $125,000 PPP funding. Then you go down and you start working your way through the eligible costs. You start with those top line payrolls, add in the 3 additional categories, but remember there's a cap for those non-payroll expenses. And so in our $125,000 example, it's capped at 25%. The maximum you could count would be $31,250. Our company here in this example spent $45,000 on other eligible expenses. So they're capped at the maximum, $31,250. Then you go in, you add your eligible payroll costs, and you see already this company is subject to an 85% reduction, or a 15% reduction down to 85% of the amount they borrowed because of that reduction created by the cap on other eligible expenses. You can spend up to 100% on payroll, no problem whatsoever, if that were to happen. But at the same time, 25% is the cap for the utilities. Then you get down into your full-time equivalent calculations. Here are the relevant time periods that you look at. Here our hypothetical business had 15 people at this time last year, had 10 people this year, so we had to downsize. We'd want to use the 2020 calculation because that's better for us the 10 folks we had in January or February. And so then we're going to count the 8 full-time equivalent employees that we had during the pandemic against the 10 we had at the start of 2020. That's an 80% reduction. So then we now take our already reduced eligible expenses and we knock it down further by an additional 20% because of that ratio. So now we're only down to possibly forgiving 68% of our allowable forgiveness. And then for every single employee, here's the calculation. You look at what their wages were in the quarter before the 8-week period. This employee makes $40,000 a year, so he or she had $10,000 in the prior quarter. We had to keep them at least at 75%. Therefore, if we didn't pay him or her $7,500, we're subject to a penalty. We actually paid him or her $2,500, which means we had a $5,000 non-permitted reduction in wages. Okay, that's counted then on a dollar for dollar basis. So our 85 drops to 80. Because of this cascade through the waterfall, we're now at a $45,000 reduction off of our 125 starting number. We use this as, in essence, an example to show you there are some nasty pitfalls on these reducers. If you're playing with, do you keep people on? Are you going to be able to hit the full-time equivalent employees? Definitely talk to your lawyers or your accountants. This is a really nasty little machine that can catch you and start knocking huge numbers off of your forgiveness application because of this. And so, would encourage all of you to consider that. One final issue that we'll flag for you is understand that there are hard deadlines for the use of PPP proceeds. Obviously, the PPP program contemplates that there will be some amount of money that's not spent during the 8-week period. That's why it's a 1% loan with 6 months of deferred payment. However, as it stands, the CARES Act implies that there's an absolute cutoff for expenditures by June 30th, 2020. That's the definition of a covered period inside of the Act. Hopefully we'll get further guidance on this, but if you're one of these businesses, and we've seen a lot of them that say, I'm planning to sit on this money past June 30th, 2020, make sure you're watching for this. Make sure you are talking with your attorneys, talking with your tax advisors, because there is a pretty significant risk that they say, nope, June 30th is a hard deadline. And therefore, you can't spend any of this money after June 30th, 2020. Remember the purpose, create liquidity, keep people on payroll. The idea is you don't sit on this money for an extended period of time. What we do know for certain, what we're all highlighting and circling and writing in red, is no forgiveness after that 8-week period. Hard and fast deadline. If you haven't both incurred the obligation and paid it by the time that 8-week period expires, you're toast. Finally, before I shift it over to Craig, and then we'll come back at the end, I've seen a few more questions come in. We'll work on responding to those. The tax treatment of PPP loans. IRS came out last week, new tax notice. What they've said is you get a benefit for the forgivable portion of the PPP loan. When it is forgiven, your financial institution, your lender, your bank's not going to send you a 1099-C for cancellation of debt. But because that's not going to count as income to you and you got free money from the federal government, you also can't take Section 162 and 163 deductions for business expenses or the interest deduction for the interest on mortgages that you paid. And so the idea is there is no double benefit. You can't double dip. For what it's worth, Congress is very upset about this. A number of senators and congressional reps have been on the news channels yelling and screaming about this issue, and so to be determined if there's going to be a change. With that said, I'm going to shift and let Craig talk a little bit about some of the changes that have impacted lenders in the last 2 weeks, and then we'll come back to some of your more technical questions you posed during the first part of the presentation. So Craig, I'll turn it over to you.
Thanks, Brad. So when reviewing the PPP through the language in the CARES Act and the final rules that came out before the first round of funding, it was clear that the only compliance controls referenced and contemplated was your BSA program and how you would implement it throughout the originations process and the submission to the SBA. There is no language stating that you can ignore your other compliance controls. It's just the absence of any reminders that compliance controls are out there and will be applicable. So the first instance we saw of this was on April 27th, the OCC issuing Bulletin 2020-45. The guidance was the first official indication that these loans would be reviewed for compliance with lending regulations outside of the BSA mandate that was outlined in the CARES Act. And within it, the OCC states that they encourage banks to collect and track information provided during the application process regarding the borrower's annual revenue and for loans made in LMI census tracts, distressed areas, underserved areas, and that benefit LMI individuals, families, and communities. That statement of encouragement is then followed by a reminder that maintaining and monitoring this information where applicable in the administration of the PPP program is a prudent banking practice consistent with the principles of safety and soundness and fair access to fair treatment of borrowers. They're all but saying that, we're going to review these for any fair lending impacts, impact to your CRA strategic plan and how it was contemplated before rollout. The benefit of the guidance is we do see some bullet points here about what prudent practices in the OCCIs include. And that's movement around setting the eligibility criteria, establishing processes for considering applications, and approving or denying PPP applications. They also state that relevant business considerations may include estimate of resources needed to implement and offer the PPP program, current available resources including FTE and staff, and the ability to access needed information about an applicant in a timely way, among other factors. You should be looking at all these data points and seeing how you documented them. If they were part of your contemplation when looking to roll out the program, if it were and you just did it verbally in the discussion, make sure you get that recorded somewhere. Did you present these issues to your board? It's all going to be relevant in 8 to 12 to 24 months when the regulators inside your office is asking these questions. Next slide, Brad. Not to be outdone, on the same day we saw a blog post come out by the CFPB. It's interesting to note who it was written by. Patrice Ficklin, the head of fair lending within the CEPL group at the CFPB. Grady Hedgestaff, which is an SBA, the director of SBA lending within the SBA. And Laura McCrae, which is small business, the head of small business and small business lending. Within the blog, it's the first time we see the CFPB state that any activity under the CARES Act or loan programs under the CARES Act are subject to anti-discrimination law, including COA, and they're going to be looking at how your rollout or loan activity was implemented in a way that protected business owners from discrimination, and go on to bullet point what small business owners of protected classes and women, business owners, businesses owned primarily by women, should be looking for as indicators of violations of COA. We can bullet those out right there for you. And the most concerning part of this blog post is they then go on to invite any small business owner that feels that they were discriminated against based on race, sex, or other protected category to submit a lending discrimination complaint online for the activity under the PPP program. For those of you who have been through, supervisory exams by the Bureau or enforcement actions with the Bureau, you know that they use that complaint portal to drive their actions, their risk-based approach to supervision and enforcement. So they're all but saying here that, look, we're encouraging people to submit the complaints because we plan to look at this and we'd like to know what the issues were. This should be a flashing red light that the Bureau is now going to be focused on this when they come back for your overview. It's also, when you read this blog post, take into account that the Bureau has been trying to push the agenda of getting small businesses lending to minorities and women-owned businesses to be tracked under HMDA. They want to do that solely to how to better situate themselves to enforce the COA in your small business lending practices. I see this as their gateway into that activity. They're going to look at pretty closely at this activity because they've been focused on it over the last couple of years, just haven't gotten around to the rule promulgation with the shift in tone at the CFPB. But we could be heading into the perfect storm with, a possible change in administration, which would then roll down to a possible change in tone of the CFPB. And when they come back in for an exam, you might be taking the brunt of that. Next slide, Brad. Then this morning, we saw an email blast that the CFPB released an FAQ yesterday titled "The Bureau's Equal Credit Opportunity Act and Regulation B FAQs Related to the COVID-19 Emergency." It's only a three-question FAQ, but the questions asked are extremely relevant. Some lenders, I can assure you, were not contemplating how the questions would impact their operations and rollout of the PPP program, so it's worth it to go over what was asked. So first, they asked for a PPP loan application received by the creditor and submitted to the SBA. Is the application being completed before the creditor has received the loan number from the SBA, or a response about the availability of funds, which would then trigger the creditor to provide a notice of action? The CFPB views this as no. They're looking at it as a PPP application that the creditor has just submitted to the SBA for processing. It's not qualifying as a completed application under Reg B. They want you to wait until the creditor receives a loan number from the SBA or a response about the availability of funds. So if you were in that first round, you submitted and then the funds ran out, you should have issued a notice of action that was taken within the 30 days of your acknowledgement that the funds ran out from the SBA. It's important to note that under Reg B, an application is completed when a creditor has received all the information that the creditor regularly obtains and considers in evaluating applications for the amount and type of credit that's been requested. This information includes, but it's not limited to, any approvals or reports by governmental agencies or other persons that are necessary to guarantee said loan. So in this case, that's how the Bureau is thinking about that process. Next question that they contemplate is if a creditor receives a PPP loan application and refuses to grant the loan, and the credit request without ever submitting the PPP loan to the SBA, does that creditor need to provide a Reg B adverse action notification? The answer there is yes. It wouldn't surprise me to learn that a lot of people were not doing this, but you should be going back and looking to see if you did. If you did not, you should be issuing those adverse notifications as soon as possible and documenting that you contemplated that issue. The final question that they contemplate here is if a creditor has gathered sufficient data from the PPP applicant for the decision but has not received the loan number from the SBA or a response about the availability fund, can the creditor deny the application based on incompleteness? No, they can't. Under Reg B, you can only deny for incompleteness if an application is incomplete regarding the information that the applicant can provide, and that the creditor lacks sufficient data for the credit decision. In this case, if it's submitted but you just haven't had a response or an update for the availability funds, there's nothing more the borrower can do, so you can't issue that denial until you hear from the SBA. Next slide, Brian. Another thing to contemplate here is vendors, your third-party oversight. Did you onboard any vendor to assist with your FTE scaling in your response to the PPP program? Did you contemplate what you normally would for vendor onboarding? Although we rolled this out in a matter of weeks, the regulators are still going to look to see if you contemplated if it was a necessity to outsource the functions that you onboarded the vendor for. What diligence did you conduct with the said vendor? Did you have internal competencies to oversee these vendors? Meaning, did you put it through your normal TPO oversight? Are they going through any ongoing review or QA process? You want to look to see what the MSA vetting was. Did it go through legal? Did it go through compliance? How is the vendor reporting SLAs up to you? How are they reporting consumer complaints up to you? Are you using those consumer complaints to kind of drive any remediation efforts in the PPP? For example, this would be a great opportunity to showcase how you're implementing a COA. Are you looking at any fair lending allegations within that complaint population and kind of drilling down to see if it has any validity to it? If it does, are you remediating the process in any way? And that'll go through servicing and forgiveness as well. You'll still see these issues pop up. You're also going to want to look at what data is being shared with this vendor. What access did you grant the vendor to your core systems, to your consumer data? Did you market through them? All issues that are going to be looked at and reviewed by the regulator come exam time. Next question, Brad. Regulatory risks. We're starting to see our colleagues in the larger banks issue their 10-Qs. The first one that I highlight there is from Wells Fargo that was issued late yesterday. They make the statement that plans to file punitive class actions in state and federal courts in Texas, California, and Colorado against the company, and that the actions seek damages and injunctive relief related to the company's offering of the PPP program. They also, that last sentence there is worthy of highlighting. The company has also received formal and informal inquiries from federal and state governmental agencies regarding its offering of PPP loans. So this is the first actual evidence that we're seeing of the regulators coming in there and starting to make the inquiries, whether they be formal or informal. We don't know what they were questioning or if they had issues around the rollout, but we know that they're starting to ask already. It's just going to ramp up as this plays out in the news cycles, and you see these loans go through forgiveness. The borrowers start to have issues with the forgiveness process, with the servicing process, with the denials or the availability of funds. The first thing that's going to happen is the regulators are going to start to come look at you and what your controls were around the rollout of the program and what issues were you contemplating, how are you controlling the lending of these funds. Bank of America also issued their 10-Q a couple days earlier. They just put a statement in there saying that fines and reputational damage resulting from pending or future litigation and regulatory and government actions, including a result from our participation in and the execution of the COVID-19 loan program. So they're anticipating it as well. We also saw Jamie Dimon in his investor call back in April. He referenced the PPP 3 or 4 times, but mostly from a capital requirement and liquidity function, not really from the reputational or the regulatory risks that are being presented through the program. And that may be a function of, that call took place in mid-April versus what we're seeing the banks say in early May in their 10-Qs, now that more guidance has come out from the OCC and the CFPB. Next slide, Brad. We do also want to highlight some other reputational and litigation risks associated with the program. So you are going to have UDAP, either UDAP under Dodd-Frank or single A UDAP under the state laws. So with the limited guidance out there, you should be asking questions of your processes and your rollout, like how are you handling inquiries from your customers? If they're going to loan level employees, does that employee have the ability to answer intelligently about the program, about the processing of the program, who's offering, what the forgiveness looks like? Initially, those UDAP concerns are going to be around the origination. As you get towards forgiveness, especially as that prepayment date comes closer, you're going to start to see inquiries come in from these borrowers saying, what's my liability under the payment and the forgiveness function. If you don't have your loan level employees intelligently prepped or trained on the matter, you're going to expose yourself to a lot of UDAP risk there, deceptive practices, abusive practices, just by giving out the wrong information. Very similar to what we saw in the last downturn when you had loan level employees answering questions incorrectly about other government programs that were out there, funds received. You start to see litigation months after, but you could start to curtail that now. You want to ask, did you deploy FAQs? How did you train the borrowers? Did you prioritize the submission in E-Tran in any way? If you did prioritize, what was the prioritization? Did you vet that prioritization through the proper legal and risk controls? Did you track the completeness of submissions and assist customers in a meaningful and intelligent manner? We're also starting to see class actions arise with a private right of action. We saw Profiles Inc. versus Bank of America. That one was tossed by the court 2 weeks after it was filed. It was filed on the first day of PPP availability. We also saw Scherer versus Wells Fargo, which is still pending. There's a few other class actions in California as well that are pending out there. But you're starting to see plaintiffs' attorneys kind of aggregate the actions, whether it be from a deceptive practice or from a fair lending point of view, where they didn't have access to funds or they weren't properly processed. Next slide, Rob. So we want to kind of close this out as what can you do now to limit your liability? It's pretty much the same that we've been driving home since the program was initiated, but it's becoming more and more clear that your liability is going to be driven by how well you document, what you document. So you should just be focused on documentation, more documentation. Do you have policies and procedures around the rollout, around the servicing, and around the forgiveness? If you don't, can you go back and kind of document the controls that you had in place, given the quick timeline? You want to control the narrative there that you were aware of the risk, but might have been driven by the desire to help small businesses and help the country by getting these funds into the hands of borrowers. You want to document any discussions with the board of directors that you've had, with senior management that you've had. You may have mentioned this in passing, but did it make it into your board minutes? Is it in your proper risk committees, the discussion of the rollout? Are you continually discussing it? Even though it's going to wind down, you want to make sure that you're escalating and highlighting the risks associated with servicing and forgiveness. Did you do any internal reviews and assessments? If you haven't, it's still not too late. It's always better to document these controls and kind of contemplate these controls, even if late. It's better to do it now late than try to reconstruct this 12 months from now when you have a regulator asking the questions what was done and why it was done. Did you outline the timeliness for implementation? The continuous rollout of guidance here could actually work for you. You want to make sure that if the regulator finds any errors or any allegations to fair lending violations, did that occur prior to or post the OCC and the CFPB releasing that guidance? If you haven't been issuing adverse action notices, but the CFPB released that FAQ today, make sure that you're issuing those adverse action notices post and kind of just craft the narrative around that you caught it because your change management process was out there to become aware of additional guidance from the regulator. What were your business justifications? Are you looking at the shift to default to lead to a downfall in net revenue or net income over the next 2 quarters? So you're looking to produce as many of these loans as you can in order to create the fee income to kind of carry you through the next 2 or 3 quarters. What's your document retention policy look like around this program? You're going to want to make sure that you're retaining all the email communications around the program, whether it be from a compliance perspective or a legal perspective internally, or in between borrowers, because you're going to start to see these allegations of improper treatment come out in the course of the coming months. Also, did you deploy any back testing, any QA or QC? Did you do any regression analysis on the loan portfolio? Are you putting that with your regression analysis that's done in the normal course of business for your fair lending control? It's not too early to be thinking about that, and the more information that you're on with now, the better your narrative will be when this comes to the supervision portion of the timeline. It's very important to contemplate all these 7 issues here that we're outlining. If you haven't formally done it, we recommend that you get moving on that as soon as possible, just to limit your regulatory exposure in the months to come. I think that's it, Brad. If you want to skip to the next slide, we can open it up for questions.
Yeah, absolutely. And we're going to try to go back. We've had a lot of questions coming in, and we're going to go back and try to pick some of those up. One thing I will say for our lender clients who are on the call, if you need assistance with this, feel free to reach out to your Nelson Mullins contact. We're developing a formal process to help our lenders and financial institutions document these items in a way so that if you do get scrutiny 6 to 12 months from now, there's a way to go back and really think about how you're going to organize your rollout of this program, because obviously, everybody wanted to help these impacted borrowers. This is small business. This is the heart of the United States and how we keep people employed and how we conduct business in the U.S. And so, we even heard people on Senate banking saying, the goal of this program was speed, and then focus on the program itself. We needed the money. They wanted to get it out quickly. And that's obviously what the financial institutions and the lenders did in this case. We're going to be on for a while. That concludes the formal part of the presentation, but I will pick up some of these questions that have come in. Someone asked during the application process, they were required to document payroll versus other items. How does that factor into the forgiveness? That was used to set what your 2.5 times monthly expenses were. It actually has no true bearing on the forgiveness. The forgiveness is in essence reset, and you can only count those 4 categories: qualified payroll costs, mortgage interest incurred prior to February 15th, rent obligations incurred prior to February 15th, and then finally utilities where service was established prior to February 15th. There's been some clarification that utilities is designed to be read broadly, and so you potentially can include other things like gas for vehicles and things of that sort that were required during that period. Now remember too that there is also a broader definition of what is eligible expenses that are not subject to forgiveness. Importantly, that picks up the refinancing of EIDL loans if you got one of the, or EIDL grants, one of those loan grants through the SBA. That's a qualified expense if you had to refinance it because you used it for payroll costs. Also, interest obligations on non-mortgage debt incurred before February 15th, 2020 come back into play as an allowable expense. It's just not subject to forgiveness. Somebody raised the question that if someone were to obtain a PPP loan as of today and we start their 8-week period, that would extend beyond June 30th. That's exactly right. The covered period is defined both ways, both as the 8-week period and the period ending on June 30th. We're hoping clarification comes out as to all of these expense periods. But in that case, it appears you would at least get the 8 weeks following the date of disbursement in those. Someone else asked if someone is out on Family Medical Leave Act and not getting paid, do you count them as a full-time employee? AICPA has issued a series of requests to SBA to clear up some of these questions. The short answer is if you look at how they are treating other employees, the idea is in order to be counted as a full-time employee, they must be working 30 hours per week, or they must be getting a salary that is at least equal to minimum wage times 30 hours per week. And so if they're out on FMLA and are not presently working, and the amounts you are paying them is less than that 30 hours per week rate, odds are you're probably not going to be able to count them as a FTE. They also, a number of folks have asked, what if someone is terminated due to behavior? How is that treated? It has nothing to do with COVID. By all means, you can. And the safe harbor allows you to replace them. It doesn't require that the same employee fill each of those boxes. In fact, specifically in order to hit that June 30th rehire deadline, you could rehire an entirely new employee group if you would like to, in order to avoid these penalty provisions. It does not require that it be the same person that you had for the baseline calculation. Someone asked, what happens if someone retires during the period? The answer is no one knows. AICPA has been yelling and screaming about this. The guidance regarding people who refuse to come back to work was done as a special exception outside of the statute and outside of the regulations. They're given some what's called flexibility for de minimis or non-meaningful decisions, and they use that power to bring people who refuse to come back to work back into the mix. We don't know yet if they would exercise that same discretion in order to pick up individuals who had been retired. The challenge, obviously, with the folks who are retired is going to be you were no longer paying them and you potentially counted them into your baseline. So AICPA has argued either you take them out of both calculations or you're allowed to keep them in both calculations so you're not penalized because people retire of their own fruition. Someone else asked, can you go back and issue bonuses? Potentially. I will tell you what the AICPA says, and then I'll tell you a potentially more conservative approach. The AICPA says that you can offer hazard pay, incentives during the period in order to fully eat those payroll costs. And their position is there's nothing that prohibits you from incurring additional employment obligations during the 8-week period. The same argument can be made. There's nothing in the statute that says you can, and when it came to mortgage interest, rent, and utilities, they said it had to have been, what pre-existed as of February 15th. I wish I had a good answer for you. Hopefully we get that in the forgiveness guidance that comes out, but it's a huge open question. as to how you would treat additional incentives. Some people say they want to go back and catch up reductions in salary. Others have said they want to just issue bonuses to their employees. Some have said they want to issue hazard pay to their employees. All wonderful ideas to help get money out into the workforce. But because of that pre-existing obligation, the question is, can you go back and do it? And there's presently no clear guidance. And so that's something you'd really want to talk to your attorney or accountant about before you pull the trigger on any of those. What we know is you cannot take on additional obligations. Similarly, if you were going back and paying an obligation that was incurred outside of the 8-week period, meaning you failed to make payroll, that potentially is disqualified because the act is clear that the obligation must have been incurred during the 8-week period and paid during the 8-week period in order for it to count both ways. Finally, someone asked, did healthcare benefits such as group health and disability insurance qualify? Yes, it does. And, one of the things to be aware of is some of these fringe benefits can exceed the $100,000 per employee compensation cap, meaning when we talk about payroll costs, generally salary, wages, and direct compensation cannot be counted if it puts someone above 100,000. The guidance has come out that you can, through benefits, put people over 100,000, where you potentially would pay them $100,000 in salaries and wages, and then pay their group health and disability. You'd pay their various other benefits plans that are allowed under the act, and that would take you above the $100,000 limit, still be a permissible expense for purposes of determining the forgiveness. Few logistics. Some folks have asked, is a recording of this webinar available? Yes, it will be available this afternoon. All of our In the Trenches webinars on all of these topics, including PPP1, are available on YouTube and on the firm's website. And everyone who participated today will be getting copies of the slides that we used. If someone asks if you were calculating FTEs for the 8-week period, if someone does not work but comes back to go to work, do you count them as an FTE? No, it actually is based on an average over the period. So if they didn't work one of those 8 weeks, you would then, when you're doing your average number of employees during the 8-week period, you would have to reduce that week as you calculate the overall average employees during that 8-week period. And so, if you had 10 when you started, because that person didn't work one of the 8 weeks, you would at that point have 9.7 or 9.8% retention of FTEs. There's this concept that the FTE is not, you round up or round down. Instead, you potentially could have an average of 9.8 FTEs during the 8-week period compared to 10 during the prior period. Then let's see. Someone asked if we make PPP loans outside of their typical lending area, would they need to provide decline letters for those companies that applied for a loan that were located out of state or not in our market? Craig, you want to address that one? I mean, from a ECOA fair lending standpoint, if somebody was not, was just simply not eligible because not in your footprint, how would you handle that?
Yeah, you'd have to. Going back to that FAQ, I would have answered that question differently yesterday than I would today. Today, it seems like from that middle question within that FAQ guidance that we highlighted that you would have to issue an adverse action notice there. It's unclear as to what you would put as the cause of denial. I guess it would be a summary of the lending criteria for the bank itself, whether you're just doing loans within your footprint. We are seeing that just your footprint or just your existing customer base is being viewed as compliant from the regulators. If you put any other qualifiers on that besides just the footprint or portions of your footprint or consumer base with existing in-use credit products, you're going to start to run into ECOA issues there. But if they're just outside your footprint and that's the consistent way you've been treating the loans, I would just issue the adverse action notice.
Yeah, one thing I'd add to that too is just remember that for ECOA purposes, there is that definition of when application is made. We've had some people come up where if you had a portal for individuals, and it says name, location, and when they select the state in which they're in, it says, "I'm sorry, we don't offer loans in that particular state." I think you've got a decent argument that they never made a capital A application under ECOA. But that's something certainly to think through. If you actually took their application, they went through the process of applying for credit, then that's going to trigger the ECOA notice obligation, even if it was something like that. There was just a straight knockout criteria that would have been available. There is one final question here we'll answer that was a question about bonuses if they weren't paid previously, and then can you go back and catch them up? If they were discretionary bonuses and the obligation was not incurred prior to, and you now want to, and it would be normal for you to issue bonuses, something to talk to your attorneys or accountants about. But there again, I think you're getting into what would be more normal for your business, which is you typically paid bonuses, and therefore it would not be abnormal. You'd be incurring the new obligation to pay bonuses when you announce them during the 8-week period, and you would also be paying them during the 8-week period. But like I say, I really caution folks about getting too crazy about that. Everybody is warning their clients, all of the CPAs, all of the law firms about, don't go back and suddenly, everybody gets a $25,000 incentive during that period just to eat through PPP proceeds, because that could be then viewed as abnormal, not true payroll expenses. We don't know. We hopefully will know when the new forgiveness guidance comes out, as well as some of the new guidance on necessity, because obviously lots of people are struggling with those particular questions. That concludes, it looks like, all of the questions that we've had submitted. Thank you so much for being such a inquisitive group of folks. Hopefully this was helpful for you. As we mentioned earlier, all of the slides that Craig and I prepared, as well as the recording of this webinar, will be up on the firm's website. Feel free to reach out to your contact at the firm if you have more detailed questions. Again, this is designed to be an informational presentation, and we can't get into significant details in terms of your particular fact situation without kind of fully exploring that with you. But we appreciate everything that you as lenders are doing to keep these businesses open and keep liquidity. We know this has been a challenge as you've gone through this process on this expedited timeline. Understand everybody supports what you're doing. We're here for you. Your businesses appreciate you. And then especially for the folks who are borrowers on the phone today, 75% of America's workers, I've heard, depending on how you count it, are employed by small businesses. You keep the economy running. Everything that can be done to help you, that's what the banks, credit unions, and lenders are here to do, and they're out here to support you. And we just appreciate you guys being in the trenches and working your way through this process. So thanks, everybody. Have a great afternoon. We'll talk to you next week as we continue our In the Trenches program.
Thanks, guys.